Well, thank you, Saskia, and it's been a great delight to work with Saskia, and we've already done some work on a German case together, a German forger who we're very interested in, who has been extraordinarily successful and has put an awful lot of false paintings out into the marketplace in Europe and elsewhere. But I'm not going to talk about that aspect of our collaboration today, but rather about a case that I became involved with here in Australia. And I want to really use it as an illustration of how there are serious fault lines in the protection of our cultural heritage and other cultural heritage from other countries as in the legal situation. And I'm afraid some of it is a little legalistic, and I apologize in advance for that, but I hope that you'll find some of it interesting. Where are we? Here's the thing. Some of you may have, a few weeks ago, seen the major publicity that occurred around the National Gallery and its acquisition of a dancing Shiva, Hindu work of art dating from the 12th, 13th century, and suggestion that it might in fact have been the product of purchase from this gentleman who looks very respectable, Mr. Subhash Kapoor, a antiquities dealer, Indian citizen, but now an American citizen as well, who had sold this artifact to the gallery several years ago, as well as quite a deal of other art objects from India and elsewhere to other galleries around the world. Mr. Kapoor was arrested in Germany last year and extradited to his former home in India on the basis of that he had had a systematic series of temple looters in India who had been supplying his trade with large numbers of artifacts to considerable value. In fact, a raid on his warehouses that he kept in New York City by the by the federal authorities had uncovered some $30 million worth of items that had been stored there of artifacts. And these were items all believed to have been looted from various places. As a result of this publicity, the National Gallery of Art was one of, as I say, quite a large number of international galleries of great repute, including the Metropolitan Museum of Art, the Los Angeles Contemporary Art Museum and others, that said that they had bought from Mr. Kapoor. And the NGA said that they had 21 objects, in fact, from this particular source. The Art Gallery of New South Wales, which we've just heard about, lost its Cavalier, had, on the other hand, bought some works from Mr. Kapoor as well, and they had 6 objects. And our new director at the Art Gallery of New South Wales, extraordinarily distinguished art historian and expert in this field, who had been the former director of the Getty Museum. So those of you who are into this field realize that the Getty has a certain checkered history in this area itself, and Michael Brand did a good deal, I think, to try and prevent them getting further hooked into this area, but he left there, I think, in not great support for their policies. But Michael Brand said no one's had any suggestions that the works in our collection of stolen art, but if there were, then we'll certainly address those issues. And as I understand at the moment, both the National Gallery of Art in Canberra as well as the Art Gallery of New South Wales are collaborating with the Indian authorities to look and see whether in fact these are stolen or looted objects or not. Well, I mentioned this because it illustrates that in Australia, like other parts of the world, looted items of property are likely to appear in our art galleries and should not appear in those galleries if they did proper provenance tests and so on, from sources that may be extremely dubious. And indeed, my dear friend and colleague Ken Polk, who unfortunately couldn't be here today, but he has been pointing out to me quite some time now that he's seen quite a number of these objects in the galleries, and that he's had strong doubts about their legitimacy and that they could not possibly have been acquired lawfully by the people who sold them to the gallery. So one of the things that happens if there are items that are brought into the country, or indeed items of cultural heritage that are sought to be exported, they are protected under our legislation by a Commonwealth Act, the Protection of Movable Property Cultural or Movable Cultural Heritage Act of 1986, which sets up a regime to try and stop objects which have cultural value being taken out of our country without proper due diligence as to whether or not they should be protected and an export license not provided, or whether or not they could be taken out and lawfully by whoever it is who's purchased them and wants to have them go out of the country. But at the same time, there's also another mechanism to protect items that come into Australia which have been obtained elsewhere and which are believed to be unlawful imports, in the sense that they have been a protected object of a foreign country that has been exported from that country, that the export was prohibited by a law of that country relating to cultural property, and that it has been, in fact, imported into Australia. And if it meets those criteria, then the object is liable to forfeiture when it comes into Australia. And indeed, if it were to be established that these other items are, in fact, from the National Gallery and the Art Gallery of New South Wales, items have been stolen from their original source, they could in fact be liable to forfeiture, although it's much more likely that they'll be returned voluntarily to their original owners by the people who have them at the moment. But I became involved in a case where, in fact, this power had been exercised, which is a power exercised by the federal customs authorities in Australia, working with our cultural heritage authorities, all federal agencies. And the body that was in fact the subject of a forfeiture was BC Galleries. Now I have to be very careful what I say now, because this is both a case that is still live in the sense it could be appealed, and also I have to watch out for defamation here, since there are a history of galleries and gallery owners suing even innocent criminologists like me. So BC Galleries, if you can go to their website, and you'll find, here it is, that they sell an enormous array of antiquities. And if, I stress, if they are genuine antiquities, which I suspect a significant proportion are not, they could not have been acquired lawfully under the situation of the countries from which they've been obtained, since they've been seized. They've been basically, you can't get access to objects from our region, or from Greece, or from Egypt and other places. There are stringent protections about their export, and none of these I suspect have that provenance that's required. In any case, the authorities decided, after an investigation which I was partially involved with, and even more so my friend Ken Polk, seizures were made of a number of objects. Here's the power that they have to do that. The inspector may seize a protected object that the inspector believes on reasonable grounds that they should be forfeited, for the reasons I've just spelled out to you, that they've been unlawfully exported from the country of origin. Now, I'm sorry, I apologise for the quality of these slides, since they didn't come through very well in scanning, but I won't go through all the items that were seized, but one of them was a Northern Chi painted pottery ox, dating from the 6th century AD from China, and they were accompanied by, according to the information on the website for sale, by a thermonuclear or thermoradiography certificate testifying through carbon dating that they were from this particular age. There's a much better picture of one I took recently in Hollywood Road in Hong Kong, where you can buy these objects as well. Again, not lawfully in the sense that they are obtained from China lawfully, but you can certainly buy them in Hong Kong, which is a free port. Some more of them. There was also a Tang Dynasty stone pillar, a number of items there with very large objects dating from 600 to 900 AD. A lovely ceramic statue horse from the Northern Dynasties period, and an Eastern Han money tree, which are very rare and very valuable, and date from much earlier period, 25 to 220 AD. That's an actual one from a museum, just to give you an idea what they look like in colour. Lovely objects. So these were seized from BC Galleries, and when they are seized, then the person who claims that they are in fact their objects and they have lawful possession of them then may bring an action themselves to have them recovered and given back to them on the basis that they have lawful possession. So the case I became involved with, in this case with the expert witness, arose when the BC Galleries brought an action against the Commonwealth of Australia seeking to recover these seized objects on the basis that they weren't objects which had been unlawfully exported from China and that they had been quite lawfully obtained by the galleries and were quite properly available for sale. Now, the action took place in the Federal Magistrates Court in Melbourne, and the onus of proof, in fact, was ruled to be not on the person who brought the application, but in fact on the Commonwealth. And that was the first of the rulings that were made by the magistrate, and one which in essence probably was the fatal one in terms of the success of outcome of this, if you're looking at it from the perspective of the Commonwealth. Because the Commonwealth then was faced with the possibility of having to show that it was in fact a protected object that had been exported to the country, prohibited by that country, no doubt had been imported here. And the magistrate accepted on the basis of the evidence the objects were authentic and part of the cultural heritage of China. But there was an expert who was also tasked by the Commonwealth who found that the stone pillars were in fact, he said, fakes, 20th century fakes, even though they'd been advertised by the gallery for, I think it was $30,000. All the objects, in fact, were purchased originally in Hong Kong by the person who brought them into the country and imported here. And the magistrate said that he could not be satisfied on the object from the evidence that was there that the objects had originated from within the geographic area of China. He said that there was no evidence that the Han dynasty from which these others had come and the others overlapped with the actual geographic boundaries now of China, so that there was no way in which they could be satisfactorily found to be exported, and nor was he satisfied that they were prohibited from export either. There is, in fact, under Chinese law, is unlawful to export any object which dates from prior to 1911. And that's a very clear part of Chinese law. However, I was called as an expert, as I say. The magistrate ruled that I was not an expert as far as it came to the law of China, or in that case, the Philippines. In fact, I didn't speak Mandarin, and I also hadn't practiced law in China. And as a result of which, he was left to interpret the law himself, and he got it horribly wrong. I can tell you when I read the decision, absolutely horribly wrong. The result of all this is that the Commonwealth failed to prove that the objects were liable to forfeiture, and they were ordered to be returned to the galleries. Now, that's just a case, an example. What is perhaps more troubling is this is the first occasion that the Commonwealth has invested all of the resources that it has in order to get a seizure of this nature. The Protection of Property Act has never been, this clause has ever been used before, and it's probably not likely to be used again for some time as a result of the way this case prevailed. So I'm afraid the message is not a very happy one as far as the protection of cultural heritage of other countries is concerned, just as I suppose one has to say from the viewpoint of the gallery owners, they're probably very happy with the outcome. Thank you.